Hello everyone, welcome to the sixth video of our video series titled Introduction to the Constitution of Bangladesh. I am Mohammad Rafi Ibn Masud, an LL.M candidate from the University of Dhaka presenting on part 6 of the Constitution of Bangladesh in this video. Part 6 deals with the judiciary. It is divided into 3 chapters that correspond to the subject matter and hierarchy of the judiciary, which are the Supreme Courts, the subordinate courts, and the administrative tribunals. Let's have an overview of the Supreme Courts first. According to Chapter 1, there must be a Supreme Court which would consist of an appellate division and a High Court division. There shall be a Chief Justice appointed by the President directly. The judges shall be independent to perform their functions without the interference of the legislature. Chapter 1 contains all the rules and procedures for the appointment of the judges. This chapter determines the eligibility of a judge, which is that a judge must be a citizen of Bangladesh who has either been an advocate at the Supreme Court for a minimum of 10 years or has held a judicial office in Bangladesh for 10 years, and they can serve until they have attained the age of 67 years. Chapter 1 of Part 6 determines the jurisdiction of the High Court Division and Appellate Division. It grants the High Court Division the authority to issue certain orders and directions. It also grants the Appellate Division the power to issue directions, orders, decrees, or writs. The Appellate Division will have the power to review any judgments or orders issued by it. According to this chapter, the Supreme Court has the power to make rules which regulate the practice and procedure of each division of the Supreme Court and any other subordinate court. It also states that the Supreme Court will have superintendence over all courts and tribunals subordinate to it. Supreme Court judgments carry precedential value and shall be binding in all subordinate courts in the Republic. It also states that all authorities, executive and judicial in the Republic, will act in aid of the Supreme Court. Chapter 2 focuses on subordinate courts to the Supreme Court. Like the Supreme Court, the appointment of persons to offices in the judicial service or as magistrates exercising judicial functions will be made by the President. It vests the control and discipline of subordinate courts in the President and will be exercised in consultation with the Supreme Court. It also states that all persons employed in connection with the judiciary shall be independent in performing the assigned judicial functions. Chapter 3 empowers the Parliament to establish administrative tribunals to deal with particular matters exclusively. Currently, there are 7 administrative tribunals in Bangladesh, as you can see in the slide. One of the key concerns of our Constitution regarding the judiciary is its independence. The Constitution has established it as an independent organ of the state, as Article 22 of the Constitution provides. The state shall ensure the separation of the judiciary from the executive organs of the state. Moreover, Article 94, Clause 4 of the Constitution states that the Chief Justice and the other judges of the Supreme Court of Bangladesh shall be independent in the exercise of their judicial functions. The same view is also reflected in Article 116A regarding the judges and judicial magistrates of the subordinate courts. To cement the fact that the judiciary is an independent organ of a state, in the Mazhar Hossain case, it was opined upon the provisions of the independence of the judiciary affirmed in Article 94, Clause 4 and Article 116A as one of the basic pillars of the Constitution, which could not be abridged, curtailed, or diminished in any manner. Now, one of the highlights of Part 6 is the writ jurisdiction. Article 102 confers writ jurisdiction to the High Court Division. In writ jurisdiction, the Honorable Court grants immediate relief against the illegal, unreasonable action of an administrative authority, judicial or quasi-judicial action. The Constitution of Bangladesh has empowered the High Court to issue writs, directions, orders, etc. Writ is equal to a weapon that enables the citizen to protect his rights, including fundamental rights, by directly moving to the High Court Division through filing a petition before the High Court Division under Article 102 of the Constitution against illegal violation of the rights of an individual. Through writ jurisdiction, one can file a PIL, and many successful PIL cases has been adjudicated, ensuring justice for people at large. Moreover, there is scope for judicial activism through Article 102, where judges can issue suo motu. Article 102 of the Constitution allows 5 types of writ. They are writ of prohibition, writ of mandamus, writ of certiorari, writ of habeas corpus, writ of quo warranto. At first, let's talk about writ of prohibition. In the first part of Clause 2 of Article 102 of the Constitution of the People's Republic of Bangladesh, the High Court Division is empowered to direct a person carrying out any functions relating to the affairs of the Republic or a local authority to refrain from doing what it is not permitted by law to do. It therefore deals with the prohibition writ that is given to refrain an individual from acting if the conditions listed are met. The conditions are: 1. The application must be filed by an aggrieved person. 2. If there is no equally effective remedy available. 3. If the wrongdoer acts without jurisdiction or in excess of jurisdiction. And 4. It's done by a person performing functions in connection with the affairs of the public body. Moving on to writ of mandamus. The second part of Clause 2, Para A 1 of Article 102 authorizes the Division of the High Court to issue instructions in the nature of mandamus writs. Mandamus is an order of the High Court Division when the court or the person is compelled to do his statutory duty upon the failure of the individual or court to perform his statutory duty. The distinction between mandamus and prohibition is that mandamus commands the public official to do what they are under a legal duty to do, while prohibition is given to avoid them from doing what they are not allowed to do by law. Then comes writ of certiorari. This writ power has empowered the High Court Division of the Supreme Court to control the action of the inferior or subordinate courts. For example, whether the subordinate courts in Bangladesh are functioning within their jurisdiction or in excess of their jurisdiction. The conditions are very similar to the writ of prohibition. Then comes writ of habeas corpus. Habeas corpus is a powerful tool to safeguard the freedom which is essential for a democratic society. It is awarded by the police authority against wrongful detention or deportation. Habeas corpus is a kind of court order that commands an individual held in custody by the authorities to bring that person to court. Authorities are bound by the court order to present him before the court and disclose the reasons for the detention. If the court is convinced that the detention is unnecessary or illegal, the court may order to release of the detainee. Habeas corpus is thus a method to secure the subject's private freedom. And finally comes writ of quo warranto. Quo warranto is Latin for by what warrant or authority. A writ of quo warranto is a common law remedy that is used to challenge a person's right to hold a public or corporate office. A state may also use a quo warranto action to revoke a corporation's charter. In a writ of quo warranto, the petitioner does not seek to enforce his right but challenges the validity of the claim of the holder of a public offense. Hence, this writ can be sought by any person whether she or he has any personal interest or not. In conclusion, our judiciary has played a crucial role in preventing abuse of law by the executives through check and balance. While excessive judicial activism can threaten the separation of powers, while practiced carefully, can work as a fundamental tool to prevent exploitation by the government. As Patrick Henry said, the Constitution is not an instrument for the government to restrain the people, it is an instrument for the people to restrain the government. That's about it. Don't forget to check the remaining videos. Wishing you all a very happy World Constitution Day. Thank you.